Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman, Jr., an attorney with Temmerman, Seeley, and Coleman, LLP, a law firm here in San Jose, California. As we get started, again, we want to give you a little wake-up call that we're talking about administering a trust after death. And so we may have, we're talking about for California, okay? Bob is a California attorney, I'm a California CPA. And so for other states, we may have other situations and other rules that can apply. And always consult with an attorney when you're dealing with administering a trust. This is a great big topic. We're going to cover a few highlights. May not even be able to get through all the questions that I have. So with that, let's get started with our questions. So Bob, first of all, some people think, I've put together a living trust. Everything is taken care of. I don't have to worry about anything when I pass away, or if I have a family member, say my spouse passes away. We've got this trust in place, so everything's taken care of. Is that the case?
Well, Mike, that's a common mistake and a misconception that many individuals have, that now that they've created their trusts, that there's nothing to do in a post-death situation. And the fact of the matter is there's a substantial amount to do. Even if the trust is properly created, properly drafted, properly funded, the successor trustee has quite a few duties and responsibilities to the beneficiaries of the trust, and to ignore it would be a very drastic mistake and a very costly mistake, perhaps even to the trustee as well as to the beneficiaries.
Right. All right. So now, if the decedent had a living trust, does that mean automatically that no probate is required?
The question there, Mike, is really, is the trust funded? It's not uncommon for many California domiciled residents to have a trust drafted here in California. But the real issue is, did they change title to the various assets that they owned and put title in the name of the trustee? Because if you have not changed title to the assets that are intended to be in that trust, there's a real question as to whether the trust governs them or not. It's very common for us when we draft trust to also draft a will for the decedent that we refer to frequently as a pour-over will, the purpose of which is to pick up any assets that the decedent may have inadvertently left out of his or her trust. And so some assets may have to go through a court-supervised administration, whereas other assets do not. They can be administered privately and generally very efficiently.
Okay. Now, this is a hypothetical, no, well, is it common or unusual for families to neglect the formalities of administering trusts after a death? And are there any consequences if they don't?
Is it common? You know, in our experience, we call these trusts stale trusts. Okay. These are trusts that have been ignored for one reason or another, and typically they are the situation where the surviving spouse is the trustee and is of the opinion or belief that, well, I don't need to do anything post-death. Is it common? I would say, in my experience, maybe 10% of the cases in our office are what we would call stale trust cases. Okay. It's not terribly common, but it's also not terribly unusual. And it's this stale trust, this inattention to pursuing the administration following a death, that does just create headaches and undoubtedly creates a much larger fee cost headache for the heirs, beneficiaries, as well as the trustee.
Right. Okay, what is community property and why is that important for trust administration?
Well, it's only community property. Let's just start with the definition. This only applies for a husband and a wife or for
Okay.
registered domestic partners. So if we're not in that situation, you can ignore this question.
Okay.
But for a husband and a wife, community property is property that is acquired during marriage as a result of one's time, labor, effort, skill. Translated, that's your compensation for services. That might be your brute labor force that you rendered in terms of improving a property or something of that nature. It is not property that you owned before marriage and kept separate. Community property is not property that you inherited during marriage and kept separate or acquired by gift during marriage. That is called separate property. Now, why is that important? Well, for purposes of control, frequently a husband and wife will create a joint trust, or domestic partners may sometimes create a joint trust. And the question becomes, at the first death, what is subject to the decedent's control, the deceased settlor? The creator of a trust is referred to as a settlor.
Okay.
So I can only dispose of my half of the community, any separate property that I might own under my trust. I cannot dispose of my wife's half of the community, and I certainly can't dispose of her separate property.
Okay. Are there significant legal fees for administering a trust? And does having a living trust really save legal or other administration costs, and how and why?
Boy, that's a real open-ended question, Mike.
Yeah.
I would say, on average, the legal expenses that a trustee could expect to pay for his or her counsel are probably on the range of a third, some cases less, some cases more, of what you would have paid in the absence of a trust. Meaning, if we had to probate a will under court supervision, the fees frequently are substantially higher. That's not to say that they can't be pretty substantial. In a significant number of cases, there are issues and there are problems. For instance, you can have litigation concerning a claim made against the trust. You can have litigation over the validity of the trust. You can have litigation over whether or not a property belongs inside a trust subject to the trust terms or outside of the trust subject to the control of another. So depending upon each particular case, although it would be the general rule in my general experience that it will be significantly cheaper to administer a trust. Why? Because we're not in court. It's not invariably cheaper. There are situations where it can be just as expensive as a probate, and in some cases perhaps even more expensive.
Okay.